Hello, everyone. This is Tom Fox back for another episode, and I'm absolutely thrilled today because we have the full Executives at Risk team. Yes, Lars from Miller Chevalier, who put out one of the best newsletters on a quarterly basis, are back to talk about summer 2024. So we have Lauren Briggerman, we have Katherine Pappas, Ian Herbert, and as our new guest, we have Laura Deegan. So, guys, first of all, thank you all for doing the newsletter because it's a great newsletter. And thank you all for taking the time to visit with me again. I know we've got some pretty hefty topics, so I'm going to jump right into it. And I want to start with the DOJ Whistleblower Initiative. There's been a lot of commentary on this, both very positive, some less than positive. And so you guys typically will defend corporations. And I'm really interested in one, your assessment of this program, at least at this point. And then two, what do you think that this means for either corporate legal departments or corporate compliance departments? Are they going to be under more pressure to get it right when a whistleblower report comes in, or is it something different? So, who's going to talk to us about the DOJ Whistleblower Initiative?
I am Lauren Briggerman. Thanks, Tom, for having us. And I'm glad we're doing this now as opposed to a couple months ago when our publication came out because DOJ had not yet unveiled their whistleblower program yet. And what we were writing about at the time was two pilot programs that came out of the Southern District of New York and the Northern District of California. But just recently, a couple of weeks ago, DOJ announced their new whistleblower program, which had been discussed for several months and is now being unveiled. And yes, I will talk about its implications for companies because while it does create incentives for whistleblowers who are individuals to come in and report misconduct, I think it does create pressure on companies to self report misconduct as well. Let me tell you a little bit about the program first, and then I can give you my assessment as to how it impacts companies. It's aimed at encouraging voluntary self disclosure of certain nonviolent criminal conduct. And as I mentioned, it comes on the heels of the two pilot programs that came out of the Southern District of New York and the Northern District of California. It specifically would potentially reward individuals who provide DOJ with original information that has to be in writing under certain conditions that leads to criminal or civil forfeiture of more than $1 million in net proceeds. So there is a dollar amount threshold there. And it specifically has to relate to one of four enforcement areas: foreign corruption, domestic bribery, crimes involving financial institutions, and healthcare fraud related to private insurance. It's really meant to complement the SEC whistleblower program and fill in some holes that aren't covered there, specifically to cover foreign corruption cases not covered by the SEC program. And then as it relates to the SDNY and Northern District of California programs, they don't necessarily overlap and they aren't meant to supersede the DOJ program. Those programs really are focused on state or local level bribery or fraud related crimes as opposed to at the federal level. So the DOJ program is a pilot program and it's going to be run for 3 years. So we'll see what can be achieved in those 3 years. It is being overseen by MLARS, which is the money laundering and asset recovery section within the criminal division. And to be eligible for the program, you must be an individual, so not a company who is reporting the misconduct. But I'll go in a couple of minutes to how it implicates companies. You can't be eligible for an existing whistleblower program through the SEC or anywhere else, or a key TAM program. There are certain exclusions for certain individuals as well. And then you can't have meaningfully participated in the criminal activity. You can have played a minimal role in the criminal activity, but you can't have participated meaningfully. So in terms of the information that is rewarded potentially for this program, it has to be non-public information and information that the individual has independent knowledge of or analysis of. So it can't be something that you just hear of down the street. It's something that's you have personal knowledge of. It also has to be something that's not previously known to the DOJ. Even if there's an open DOJ investigation that already exists, it can't have already been known to DOJ. It also has to materially add to the information that DOJ already possesses, and it must be made voluntarily, truthfully, and completely. And as I mentioned before, there is $1 million threshold in net proceeds that the DOJ actually has to obtain that would lead to them granting the whistleblower any sort of award through the program. So even though it is a whistleblower program that applies to individuals, as they usually are, it does impact companies. I think first, there are incentives to encourage the whistleblower to report internally and use a company's internal reporting system, which means that the company would benefit from having a strong reporting system internally. So whistleblowers who first report internally and then report to DOJ within 120 days may receive an increased reward simply by the fact that they reported internally first. The whistleblower also gets credit for original information provided by a company if the company responds to an internal report by investigating the issue and then disclosing it to DOJ. But the whistleblower can also report to the DOJ directly without first making the internal report. So the incentive is designed in part to address concerns from companies that this program may weaken internal reporting systems and make it harder to identify and remediate misconduct using company resources. I do think it creates some pressure on companies to self disclose as well, not just for whistleblowers to first report internally, especially private companies based in the US that are operating internationally or other large companies with ties to the US generally and financial institutions not already covered by the SEC program. And that's because, as I just mentioned, companies can receive voluntary disclosure credit if they report within that 120-day window after the employee first reports the information internally. So I think that narrow 120-day window is a deliberate attempt to incentivize prompt reporting by companies. I think it does create pressure on them to do. And I think it also gives a little bit more definition of what prompt disclosure is under the criminal division's corporate enforcement program. I think this whistleblower program also increases the incentive for companies to have strong reporting systems. As mentioned, the award to an individual can be increased if the employee reports internally first. Having strong reporting channels for individuals within the company is important. But again, Tom, it's hard to say. This is a 3-year program. We'll see how many individuals end up actually reporting and using the whistleblower program. 120 days is a short period of time for a company, of course, to report, but it's still a few months and it's only a 3-year program. So it kind of remains to be seen how fruitful this will be and what the impact will be on companies.
Lauren, over my career in compliance, I have seen the DOJ evolve and thinking in lots of different directions. But one of the things that's impressed me as is that the DOJ listens. It listens to the Bar Association, it listens to compliance organizations, it listens to people like you and me actually when we put position papers or have other public commentary. Is it your sense that the DOJ will take, discussion points or other information from, the defense bar or the compliance bar on a go-forward basis in this program because it is a pilot program?
It is a pilot program, so I hope they certainly will. But I think they also did reach out and receive comments from the industry before designing the program. So I'm not sure if they will change the program during the 3 years. We'll receive feedback from companies in that time period, and then we'll see after the 3-year period how successful it's been for DOJ and how difficult or helpful it has been for companies in terms of improving their compliance programs.
Or and I have tried to emphasize in my comments on this program why I think it's even more important for companies now to intake information, triage it quickly and efficiently, get it to the right people. And if it means picking up the phone and calling someone like yourself, they do that. Are those the kinds of discussions you have with your clients as well? Or is it something different?
Absolutely, for a lot of reasons. First, obviously, if the company wants to avail itself of the corporate enforcement program and self report and potentially obtain a favorable result with DOJ, then it needs to do so quickly. And now, with that 120-day period more well defined, that gives even more incentive to companies to intake these disclosures from individuals very quickly. And also, obviously, you want to do so quickly and effectively because you want to ensure that the problems are dealt with, they're investigated, they're remediated. It's not just so that the company can make the decision whether or not to self-report, but just so that it has a strong compliance program to begin with.
So, our next topic is perhaps, in my mind, the most evolving topic of any of the topics we discuss, and that is OFAC, sanctions, export controls. We are still having additional sanctions levied on Russia and Russian individuals. China is at the forefront of many people's minds, including the administration. The State Department has a set of sanctions. We've had sanctions, new sanctions just we're recording this in August 2024. Even this month, we've had a new series of sanctions and individuals listed. And we're going to ask our newest member of this podcast, at least, Laura Deegan, where do we begin to think through, or how does a in-house compliance professional or a general counsel begin to think through the ever-evolving set of sanctions that you guys on your team have seen up through summer of 2024?
Yeah, hi, and thanks, Tom. Very glad to be here. It's a very convoluted question, but certainly at the top of minds of senior executives of companies both in the US and abroad. And I think the part of what I've counseled different clients on relates to really having controls in place in your organization that can detect things like sanctions evasion, because we've seen a huge increase in the past 2 years, ever since the invasion of Ukraine, in the US government, particularly OFAC, the Department of State, and the Klepto Capture Task Force in prosecuting sanctions evasion that's happening with respect to sanctioned Russian persons hiding their assets through shell companies or through luxury properties, such as actions we've seen against Russian oligarchs for laundering money through super yachts and things of that nature. And part of that, of the responsibilities of a company in trying to counter these tactics, is really to know who their clients are, to understand the structure of their clients, whether they operate through any shell companies, whether their customers are trying to obfuscate who beneficial owners are of the clients. And then the other part of this is also trying to counteract things like diversion. There's also been a huge uptick in the past 2 years, and government actions have gone alongside this, of persons in Russia or other countries diverting U.S. origin goods or services to Russia in violation of either sanctions or Department of Commerce export control prohibitions. And so that could be much needed goods like certain services that are prohibited for Russian persons to receive, such as management consulting. And really, the other aspect of this is counseling clients on a sanctions and export controls compliance program that takes into account where its customers are, which isn't always the easiest sort of control to put in place. But understanding who a customer's distributors are in country, understanding what controls a customer might have to stop goods from reaching a country like Russia if it is prohibited to do.
The types of sanctions really extend, and you touched on this, from multiple agencies and even departments of the US government. Do you find them, Laura, to be consistent in approach, or is a company really have to struggle with what we have to do for the State Department, what we have to do for Treasury, what we have to do for the Department of Justice, or perhaps what we have to do for the Fed?
The good news and sort of the silver lining to more controls and more restrictions is that these agencies really have been acting very much hand in the past 2 years, particularly with respect to Russia-related sanctions. So, for example, the U.S. Department of State and the U.S. Department of Treasury both have authority under the main Russia sanctions program to designate actors in country. And they do so hand in hand often, where there'll be, if there's a big action that comes out, like a bunch of designations came out last Friday, you have both the Department of State and the US Department of Treasury both issuing designations, but doing so along the same policy lines that you see. There's targeting of sanctions evaders, there's targeting of persons who help certain Russian nationals create trust to obfuscate funds. So the Department of State and Treasury, even from my own experience having worked for one of these agencies, really do tend to work hand in hand, which is a good thing for corporate companies as the goals are the same. When it comes to export controls, obviously those fall in the lane of the US Department of Commerce, Bureau of Industry and Security, and they control a different set of prohibitions than what OFAC seeks to regulate. However, BIS is also working hand in hand with the Department of State, with OFAC, on what the underlying goals are of sanctions when it comes to Russia. So there has been this concerted effort across these agencies, and I think also across the DOJ with their own klepto capture task force in what they're really looking to and how they're work together to stop sanctions evasion. And the last thing I'll say on that is there hasn't just been this broad coordination amongst the US government, but we've also seen a lot of it across the pond when it comes to UK sanctions and EU sanctions, that you have the US government working sort of sometimes on a weekly basis to touch base with foreign countries when foreign countries are putting out their own sanctions that relate to Russia.
Laura, the not an export control expert like yourself or even sanctions, but I saw an explosion of growth in the Trump administration. That only increased to me, it seemed to me, in the Biden administration. Would it be fair to say that this commercial approach is really administration agnostic and it could continue well into the future no matter who is elected president?
Yes, I mean, that's you've seen really a steady stream of sanctions being used, I think, since the second Bush administration, all the way up through now. And I think that's something that companies should expect to see with any new administration coming in next year. And that's really because sanctions and export controls are really what some people call a cheap tool. You don't have the same cost of war the way you do with something like sanctions or export controls, where really you put a prohibition out and then you expect companies and especially banks to self police. And then obviously the US government comes on top of that with the enforcement perspective. But generally, sanctions and export controls can be such a huge deterrence because of the large amount of potential fines we've seen in the past couple of years, that often, like I said, what you see is the industry self policing. And that's a really important tool for the US government in its back pocket. And again, it's a relatively cheap tool instead of going in and adding further sort of defense measures or sending further military goods to countries to help with the war in Ukraine.
Laura, particularly during the Trump administration, I heard a lot of export control directors say it was the first time they'd been asked to make a presentation to the board of directors and that their role had been elevated, if not their title or pay, to a level that they had not seen. And I really wanted to use that to introduce the question to you. Are you helping companies put together proactive compliance programs in this arena? And do you see really at the highest levels of companies, whether it be the board or senior management, they understand the how the administration is using these and the risk of enforcement to them?
Yeah, I mean, I think especially, like I said, in the past 2 years, because of the sanctions on Russia and because of the influx of sanctions also put out by the EU and the UK, I've certainly seen clients ask for a lot more training at the board level when it comes to US sanctions and building up of things like a sanctions policy and a risk assessment, and not just thinking reactively, but really trying to be proactive. So another question comes up is, what happens if there are additional sanctions on China? How do we prepare our organization to deal with those additional measures when perhaps a company might have more business with China than, let's say, other sanctioned regions? So it's certainly something I am seeing more. And I've really seen senior executives at all different types of entities be more engaged. And I've certainly seen compliance officers giving those sorts of trainings or reports to the board more often, just because there have been an influx of enforcement actions. And some of those enforcement actions, interestingly enough, have gone after individuals. So, whenever you have those types of actions against individuals or people who might have been high up at a company and approved potential prohibited transactions, there's always this fear I, as a senior executive, could be next.
Do you also deal with the Uyghur Forced Labor Prevention Act from the trade side?
So I work hand in hand with others to help deal with the Forced Labor Act, and especially when it comes to customs issues. But from the sanctions side, there's also been a Treasury aspect to the Uyghur Forced Labor Act, in that Treasury is actively or has actively designated entities who are engaged in forced labor under its global Magnitsky authority. So that has really become, I think, in this past administration, particularly a very big focus where you are seeing companies trying to firm up what does my supply chain look like? What is that upstream and downstream supply chain look like? And do I have any entity in my supply chain that perhaps there's a risk of forced labor being used, even outside of the Uyghur context, anywhere in the world? Because some of the entities that Treasury has designated under its what's known as its global Magnitsky authority in relation to forced labor have been in other areas of the world and in other industries where forced labor, many know, is actively occurring still.
I'm going to use Laura Deegan's remarks about individuals to introduce the next topic, which is FCPA. We really did not have a significant corporate FCPA enforcement actions in Q2, but we had multiple individual enforcement actions. So I wanted to maybe ask if we could dive into those and then explore how, I guess, the collective we can use individual enforcement actions as teaching moments for corporations, or is it just the fear factor? So who's going to talk to us about the FCPA?
I'll be talking about the FCPA. This is Katherine. So yeah, I mean, you're right. It was a slow start to the year on the corporate side. The second quarter, we didn't have any corporate resolution. I will say that based on kind of filings by public companies and disclosures, it sounds like we should be hearing resolutions on the corporate side of things, but none to date. But on the individual side, I'll actually use some first quarter corporate resolutions to jump into it. The DOJ in March had this press release that kind of summarized an investigation that started in 2017 into international commodities trading companies. And they explained how they had 6 corporate resolutions, 19 guilty pleas, and 1 conviction. So 2 of those corporate resolutions were the Gunvor and Trafigura resolutions, which happened in the first quarter of this year. The one conviction is Javier Aguilar, a former trader at Vital, who was convicted after a 7-week jury trial in the Eastern District of New York. And just this month, he's also agreed to plead guilty to some additional charges in that matter that had been previously originally in New York, transferred to Texas, and now transferred back to New York based on his guilty plea for sentencing there. So a little bit of a through line from some corporate resolutions earlier this year into just this month, a few weeks ago, some additional individual enforcement. And so I think we would expect enforcement in that arena to continue. Yep.
No, go ahead.
I was going to move to a different industry. So if
Sure.
there's anything else you wanted to discuss.
Nope.
So I thought it might be helpful to talk about aviation a little bit, because there have been a couple of relatively recent developments there as well. So in July and in August, we saw 2 former aviation executives plead guilty to conspiracy to violate the FCPA. First, a U.S. citizen and San Diego resident, Julian Ayers, pled guilty to 1 count of conspiracy to violate the FCPA for his role in 2 schemes to bribe officials in South Africa in order to obtain and retain business with South African Airways, which is a state-owned company, and its subsidiary, South African Airways Technical. And then the following month, Deepak Sharma, a UK citizen and resident and former executive of a subsidiary of an aviation services company, also pled guilty to 1 count. And the scheme there was to bribe officials in Nepal in order to win a bid to sell 2 aircraft to a state-owned Nepal Airlines Corporation. So I think These are kind of the first couple of pleas on the individual side that we're seeing coming out of this aviation investigation.
In terms of how people like ourselves who counsel companies or are commentators in this arena, how can we use these individual enforcement actions? And I want to point to Aguilar because there seems to be a lot of information about the bribery schemes in his resolution, in addition to what we saw directly from Vital Trading and their FCPA enforcement. Is this something that you find resonates when you have to go out and talk to clients or potential clients? What compliance officers or in house legal department need to look for, red flags that may appear? How do you use a criminal conviction or a plea agreement to help push forward training and communication in house, Catherine?
Sure. So I think they're really helpful as examples that you can discuss openly and interrogate and think about how your system would handle them. So I think all of the resolutions that I just mentioned offer examples of how people are seeking to pay bribes, how they're hiding them, whether they're in consulting agreements or sham agreements or hiding them as fees. I think it's helpful. I find it helpful to talk to clients about these kind of real world examples so you can think about how your system would flag them, if your system would flag them, and how they would work up through your reporting mechanisms, and how you can tighten controls to ensure that things get caught early and you don't wind up down the line like these folks did.
All right. Ian, I don't want to say AML takes a second seat, but in terms of the number of high profile cases and headlines we saw in Q2, I don't think we saw as many as some of the other topics, but perhaps I'm incorrect on that. From your perspective, what were some of the key enforcement action changes or developments in the anti money laundering world that you guys reported on?
Sure, and I think you're right, Tom. I think there's probably fewer enforcement actions, but there are a couple of high-profile ones. And then I would also say that FinCEN has been extremely active in the AML regulatory space as well. But one enforcement action I wanted to highlight was related to the prosecution of Binance and its founder. And so in April, we got the sentence for Changpeng Zhao, who was the founder and CEO of Binance. He was sentenced to 4 months in prison for violations of the Bank Secrecy Act, failing to have anti-money laundering program. And it, there's sort of two pieces to it. It's a custodial sentence, so I think that's significant. But in the arena that we all work in the white collar criminal offenses, a 4 month sentence is, I would say, relatively light compared to what we're used to seeing, especially when you take into account sort of the seriousness of the allegations. Binance pled guilty last year and agreed to pay $4.3 billion for violating AML and sanctions laws. And Zhao also pled guilty. And the allegations are that Binance failed to report more than 100,000 suspicious transactions involving designated terrorist groups. And the government also alleged that the conduct included payments for the sale of pornography, ransomware, and so pretty serious conduct. And then we talk about tone from the top. According to the government, Zhao told his compliance team that it's better to ask for permission for forgiveness than permission, and that Binance wouldn't have been nearly as successful if it complied with US law. And so these are the types of allegations that I think we often see sort of pretty hefty sentences connected to. And so I was wondering a bit about why 4 months, though it's a custodial sentence, it is smaller than some of the other sentences we see. I think a big part of the reason is just the way the AML laws compare to some of the fraud and other laws that we often see criminal cases in. Zhao was charged with just a single count of violating the Bank Secrecy Act, and the guideline sentence is just 10 to 16 months. So the government and Zhao agreed mostly on the guideline calculation, which includes a base offense level of 8, and then a couple of increases for the amount of funds involved and his aggravating role. But unlike in the fraud context where you see sort of huge enhancements based on the loss value, there's no analogous enhancement in the AML context. And I thought it was interesting because Politico reported that the day before Zhao's sentencing, DOJ sent a letter to Congress asking them for harsher sentences in connection with AML violations and asking them to specifically to tie the sentencing guidelines to the risk posed to the U.S. financial system. I haven't seen that letter, but it's interesting, and the timing suggests some sort of connection with the Zhao sentencing.
And how do we assess both Zhao's conduct as sentence and Binance? So from my perspective, number one, it's almost so big, it's difficult for me to get my arms completely around Binance as an entity, but are they really a true unicorn and will never see this much AML violation or this many AML, I guess that's better grammar, violations again? Is it something we can get takeaways from and learn from? How do we use a case this unique?
Well, I think it is a bit of a unicorn because Binance is by far the largest cryptocurrency exchange in the world right now. But I think you sort of see crypto exchanges in particular and sort of related individuals and entities within the crypto industry sort of dealing with this, with the AML and sanctions requirements sort of more broadly. And just last month, MEX the company pled guilty to a violation of Bank Secrecy Act violations, same sort of thing, failure to establish an adequate AML program. The CEO, Arthur Hayes, and two other executives had previously pled guilty back in, I think, 2022, and each agreed to pay penalties in connection with those guilty pleas. But we just saw the BitMEX guilty plea last month. So I think, particularly in the crypto space, everyone's still trying to feel out the obligations and sort of a lot of these exchanges built up very quickly, and I think are now sort of coming to terms with some of these obligations.
All right. Ladies and gentlemen, I wanted to thank you all again. First of all, let me re-welcome our latest guest, Laura Deegan. Thank you for joining us with a great wrap-up of OFACs and sanctions. Lauren Briggerman on the DOJ Whistleblower Initiative. Katherine Pappas talked to us about FCPA, and Ian Herbert talked to us about some key AML developments. I greatly look forward to both the next newsletter and hopefully the next time we can all get together. Thank you so much for taking the time to visit with me.
Thanks for having